by the applicants, which are already premised on the understanding that a repayment order disentitles Mr. Zuma to raise any defenses. In other words, we shouldn't be here trying to raise any defenses whatsoever. The deed is done. Mr. Zuma has been held liable. He must now pay. But that's a very simplistic, or rather simplified interpretation of the court order, both of the High Court and of the Supreme Court. In the High Court order, the court made remarks about what is just and equitable. You have been referred, my lord, to the relevant paragraphs. But what the Supreme Court of Appeal does when it analyzes and it interprets the High Court judgment insofar as it dealt with this just and equitable remedy, it said in paragraph 44 of the judgment in the Supreme Court of Appeal. And I want to start there in order to set out the issues I intend to deal with and the manner in which I intend to deal with them. In the middle of, towards the end of that paragraph 44 of the High Court judgment, the Supreme Court of Appeal says, accordingly, there is nothing before the High Court to suggest that the order sought was not just and equitable in the circumstances. And it says, arguably, consequent upon a finding that the repayments should never have been made, it may perhaps be the only just and equitable remedy. And then in 45, it then says, a just and equitable remedy in this case, so found the High Court, requires a full and complete accounting by the state attorney under oath and an order directing Mr. Zuma to repay to the state the legal costs incurred on his behalf. A repayment order may well be essential to remedy the abuse of public resources, vindicate the rule of law, and reaffirm the constitutional principles of accountability and transparency, especially by a former incumbent of the highest office in the land. Simply setting aside the decision to pay without ordering an accounting and repayment would achieve none of those crucial remedial objectives. This, in any event, is less onerous than if Mr. Zuma were ordered to repay the amounts on demand as he had undertaken to do so. So, if one then goes back to the Supreme Court, to the High Court order in paragraph 88 from paragraph D, the state attorney is directed forthwith to compile a full accounting of all the legal costs that were incurred by Mr. Zuma in his personal capacity in the criminal prosecution instituted against him, and all related or ancillary litigation, including all applications referred to in this matter, and which were paid by the state. And then two, to take all necessary steps, including the institution of civil proceedings to recover the amounts paid by the state for Mr. Zuma's legal costs referred to in paragraph D1. My Lord, one reads that order, it's clear that the state attorney's recovery, the discretion of the state attorney to recover this, to take the necessary steps. And bear in mind, the court did not prescribe these necessary steps. It simply said to take all necessary steps, including the institution of civil proceedings. So there's a number of ways in which they could have recovered these amounts. What the court does not do here is to say, Mr. Zuma, you are ordered to pay 28 million or whatever amount they want. It could be 50 by the time that we finish this, by the time that he's 100 years, it could be more than that. So the court order does not direct Mr. Zuma to pay that 28 million. It says the state must still take necessary steps, including the institution of civil proceedings. Now, what is very interesting, my lord, is that if one looks at the parties that against whom who were cited in the High Court and the Supreme Court of Appeal.
Mr. Masuka, just go back to while you're on this point. If you look at paragraph 88B1 and B2 of the order of the court, yes, it doesn't specify, but it says in paragraph B2, to take all necessary steps, including the institution of civil proceedings, then to recover the amounts paid by the state for Mr. Zuma's legal costs referred to in subparagraph 1, D1. So the two must be read conjunctively together.
Yes.
So the first part is the quantification of it, and then the second part of it is the recovery.
Yes. Yes, that is correct.
So on what basis do you say that isn't in its terms a finding of liability?
Yes,
Mr. Zuma to refund. The quantification is a separate thing which is before you today.
Yes. Here is a problem that Your Lordship, I wish to raise. There were about 7 respondents in the High Court. The illegality was not committed by Zuma. What the court found, the basis on which these proceedings have been instituted, the court found that the state's decisions to afford Mr. Zuma legal costs in terms of the agreements that were signed at the time, those decisions were wrong and they should be reviewed and set aside. So to the extent my learned friend talks about illegality, an impression is constantly being created that Mr. Zuma had something to do with the decisions of the state which were set aside. Mr. Zuma had nothing to do with those decisions.
I didn't read it that way. I have read the papers. My understanding of it was that, and I think Mr. Bakumidi made that concession, is that Mr. Zuma relied on the state attorney, and there was a number of people who gave incorrect advice, the consequence of which brought him before the court. But he was the beneficiary of the services that were procured. So it's a question of, well, it ought not to have been paid out at the time that it was paid, not through any fault on Mr. Zuma's part, but that Mr. Zuma received the benefit. They were paying interest from 2005 and 2006 on the basis of, well, you were a party to the wrongdoing then. That's why they only claim interest, more interest, after the quantification is done. So it's the benefit that he received, and they say, well, that was an unlawfully received benefit, and you must refund the benefit.
Yes. No, I understand completely. I was involved with the case. So I understand your summary is a summary I would have given myself.
Yes.
But the so-called repayment order, what the state is directed to do is to compile the amounts which were incurred, the legal costs that were incurred by Zuma in his personal capacity, which were incurred by Zuma in his capacity, in his personal capacity in the criminal case. But the full and complete accounting of all legal costs was authorized by the state. So the accounting really was the state being asked to account for the money they paid unlawfully to Mr. Zuma. So what I'm pushing towards, and that's why I keep pointing to your lordship to look at the respondents that were in the High Court. So there are 2 things. When one looks at just and equitable order, your lordship would know that a just and equitable, the jurisprudence says that a just and equitable order, upon setting aside an unconstitutional conduct or an unconstitutional action, is to then repair, in other words, restore the rule of law. So the questions one must ask here is, What was the unconstitutional action that the court was dealing with, that it was dealing with? Mr. Zuma's receipt of the money was not necessarily unconstitutional. It was only unconstitutional because the state's decision to give him the legal costs was unconstitutional. So Mr. Zuma, relying in good faith on an ancient practice, which, and bearing what your Lordship has just said and what my dear friend said about the role of the very applicants today who are asking for this money to be paid, their role, it appears to us, the unconstitutional conduct which was committed by them is not being accounted for. There is no accounting at all by them. And yet, the very reason why we are in this position, why Mr. Zuma is in this position, is because of their unconstitutional conduct. Just identify in the judgment where it is found that Mr. Zuma acted unconstitutionally. There is none.
What do I do with the fact that I have an order of the full court confirmed by the Supreme Court of Appeal that says this is how it is? Wasn't it appropriate for these arguments to be made either before the full court or the SCA to say, well, you've got the wrong person? I mean, the judgment that was made. But
I will be short, my Lord, because I've been in this place before,
yes,
and with Mr. Zuma, this client. If this court finds that a repayment order has been issued and Mr. Zuma is liable, I'll sit down. I don't have to make any arguments, any submissions after that. If the court is finding is that on the facts that is before them, it is not entitled, or Mr. Zuma is not entitled, upon being confronted with a 28 million rand demand of payment to raise any defenses against the state, the very people who put him in that position, the very people who the court condemned and said they acted unconstitutionally, if the court says Zuma is not entitled to raise any defenses because he's tied to this, and this court cannot interpret this order to give it the discretion to look at what is being asked. And here is another point. You've now been listening, you also listened to the DA's a request to augment the High Court order. That is exactly the problem. The High Court has now said a just and equitable order is compile the amount so that Mr. Zuma is confronted with that amount of money. But you just don't confront him and with his hands tied at the back.
But that's the first part. That's paragraph D1.
Yes.
D Roman 2, to take all necessary steps, including institution of civil proceedings, to recover the amounts paid. So the first part is the quantification. On the papers filed by your client, you haven't taken issue with that. There's no case made out that services weren't rendered or that there's a problem with the individual amounts.
That's what I'm saying, my Lord.
That's not disputed.
It's not disputed. That's not the point. The point that Mr. Zuma is here, confronted with the 28 million rand bill, which was generated as a consequence of an unlawful and unconstitutional conduct of the very state that is now claiming that amount of money. How can that be just an equitable order? How can it be said that this court now has no other discretion? All it must say, there is a bill, it's not contested, pay. And Mr. Zuma cannot raise any argument about it.
But there's no claim.
No, before this court, before the High Court, 28 million was not there. There was no accounting of these amounts that had been paid. This court is now confronted with that information, and is confronted not just with that information, is confronted with a demand by the state to give effect to the judgment, essentially. But it's important, my Lord, to realize that if one is looking at a repayment order in the context of a just and equitable order, it cannot be just and equitable to leave out in the repayment order the conduct of the state. The very state that generated this kind of payments. And I accept that they're bound by the judgment. I mean, they are the ones who've been told to go and recover the money. But I'm submitting with respect, my Lord, that if the approach of this court is that it's bound by the High Court decision in the interpretation of these orders, as orders that simply say, Mr. Zuma, pay. You don't have a defense, you don't have anything, you can't raise any defense against the 28 million. Now he's confronted with this amount. And he says, but state, you state attorney, you Mr. President, or the presidency, you are the reason I am in this position. And is this court not in its discretion under section 172, 1B, entitled to say a just and equitable order would be a different order to the order they are seeking?
Yes, but if it's not in dispute that the services were rendered and that the services were paid and that Mr. Zuma was the recipient of the benefit of those services, whatever that may have been through the course of the litigation issue, then the fact that the payment was made is a problem as far as the state attorney is concerned when one has regard to the judgment. They ought not to have authorised it. He ought not to have enjoyed the benefit of those services. He ought not to have had his representation paid for. That may well be, but it doesn't detract from the fact that the court's now ordered the accounting so that he can see how much it was and that he paid back. The complaint is, if I can discern it from the submission, is not in regard to that the services were rendered and whatnot. It's that there's this lump sum now being claimed, which is, because of its amount, a problem. So
I will summarize the argument so that you hear it from me.
Yes.
The summary of a case is this. This unconstitutional conduct that resulted in an unauthorized expenditure was not that of Mr. Zuma. It was not the recipient's conduct. That is what was unconstitutional. And that is where the remedy ought to be applied to cure that unconstitutionality.
But I understood that, and my challenge is paragraph 46 of the Supreme Court of Appeals order. Because paragraph 46 of the Supreme Court of Appeals order says it's an endorsement of the High Court's order.
No, but you've got to interpret the order within the context of paragraph 45 and 44, as I pointed out. They use the word may well be a just and equitable order, which suggests they're leaving it open for this court that is now being asked to make a repayment order in the sense of directing Mr. Zuma to pay that 28 million, to explore against the defenses Mr. Zuma is raising, whether it is just and equitable for the state it's just an equitable order for the court to direct Mr. Zuma to pay the 28 million. Having regards to what, it's a contradiction in terms, because the courts have been quite clear about why a remedial action that is intended to cure an unconstitutional conduct ought to be made under just and equitable order. But in this case, what is very odd about it is that the perpetrators of unconstitutional conduct, which is the state, are excused from any liability whatsoever, even though it's clear that when a state pays money, in that money is unauthorized, or is an unauthorized expenditure in terms of the PFMA, or is unlawful payments that are made, it's not the recipient of the person who is asked to recover, to pay back that money in this punitive manner, and it's founded by the DA. What I'm saying, my Lord, is that when this court is now confronted with the question, which the Supreme Court of Appeal says may well be a just and equitable remedy, it should not close the door to the defenses raised against Mr. Zuma, because Mr. Zuma's position is a very simple one. State attorney, presidency, you've put me in this position. You've put me in a position where I am now being held liable to pay 28 million. Plus, if we follow the DA's logic, I'm likely to lose my own pension, likely to lose my home, I'm likely to live in perpetual debt until I die. But the originators of that, the originators of this injustice is the state. The state's unconstitutional conduct is the reason why Mr. Zuma is in this position. And if this court, in interpreting its role in dealing with this case, is as the state says it is, which is that Mr. Zuma cannot raise any defenses, then we can cut it short and leave. Because if Mr. Zuma cannot raise any defenses against a perpetrators of unconstitutional conduct, if Mr. Zuma is not entitled to raise any defenses against a claim raised against him by unconstitutional, by organs of state which acted unconstitutionally against him, then we might as well just leave it. Because, I mean, I'm sure Mr. Zuma would understand that the court has spoken. And the court has spoken, that's the end of it.
But, Mr. Masuku, what do you make of, if one looks at that paragraph 80 of the full court judgment, paragraph 88B?
I've made my submission.
But I want to engage you on that. The ordinary language suggests that, as I put that quantification and then steps to garner payment. The words are used to recover. That's on an ordinary interpretation of the words as they are. You say, yes, that may well be what they say, but it doesn't preclude raising defences to this. Okay, so I'm with you up to that point. You've raised a plethora of defences, but they all go to this question, to the question of the merits, the question of, is there a liability? Paragraph D1 establishes the liability. You haven't raised any defence in regard to the quantum.
No.
Which is something which has happened. The quantification has happened afterwards. So the defences you raise are in respect of an excellent order.
The order in 88D, my lord, is another issue that it doesn't have. That order does not direct the state attorney to recover the costs from Mr. Zuma. I know in the judgment it does say Mr. Zuma, it would be the right thing for Mr. Zuma to be asked to pay this money. But the order itself does not say go and recover this money from Mr. Zuma. It simply says take necessary steps, including the institution of civil proceedings, to recover the amounts paid by the state for Mr. Zuma's legal costs. The question of who has simply been obtained from the comments of the judgment, or the findings of the judgment, which are that the beneficiary of this what the court regarded as luxurious litigation is the one who must pay. But one looks at what the courts have said about what is a just and equitable order. Even this very court in the High Court, even this very High Court, what the courts do is to firstly find that there is unconstitutional conduct. No order has been found that the receipt of this amount of money, as far as Mr. Zuma was concerned, Mr. Zuma's receipt of this money was unconstitutional only because the state's decision to give him that money was unconstitutional. But Mr. Zuma did not obtain this money corruptly. Mr. Zuma, there is no finding that he exerted his power as a politically significant person in the country to force the state attorney to come up with legal opinions that were wrong. There is no blame worthy on Mr. Zuma other than the fact that he was a recipient of these unconstitutional payments that were being made by the state. And I accept entirely that when one reads one reads the judgment, there is an almost something that you can't resist, to say Mr. Zuma is the one who must pay. The judgment say
he was the beneficiary of the service.
No, but the courts.
But he didn't receive the money. His representative received the payments.
Yes, but not only that, my lord. Why is it not significant in the repayment requirement? Why is it not made significant that the payers of this unconstitutional, payers of this money, which was unauthorized payments, and these being unauthorized payments fall squarely within the PFMA. They are unauthorized payments, they are unlawful payments, falling squarely within the PFMA. Why are the payers, the very people sitting in this court today, why are they not being held liable? Why are the officials who gave this advice, the entire system that triggered this unconstitutional action, why are they not being held liable? Why is the state attorney, in its wisdom, deciding based on the order of the High Court to lock it only on Mr. Zuma because he was a beneficiary? They're not even asking any relief, any orders against the attorneys who were beneficiaries, direct beneficiaries of the money, in the sense that they did service and then they got paid. They're not even asking that. That's why they're not here. The one person they're going after is the person who, according to all the facts that are before you, is innocent of the unconstitutional conduct. So I'm saying this court has a new responsibility, which is to look at whether or not it is just and equitable in the context of the action that the state has taken to direct that Mr. Zuma be ordered to pay these costs. And I understand that the response to that is, but this question has already been decided. But I'm painting out a picture that cries out for attention. The very perpetrators of their unconstitutional conduct are the ones now going after the person. They say, well, we paid you money, but sorry, man, we paid you for over 20 years. We're paying you this money, or for over 15 years. We're paying you this money. It was unlawful to do that. Now, if this was, we point out that in our answering affidavit and together in our heads, if this was an attorney in private practice who had acted unconstitutionally, there would be a remedy. The Fidelity Fund would be approached. There would be some kind of moderation for a person in the position of Mr. Zuma. He asked for money. That's okay. Once he put it in the system had to act constitutionally. He was not asking for the system to act unconstitutionally. If he had known the very first time as he asked for this money to be, for this cost to be paid, if he had known that this was an unauthorized payment, and despite his knowledge of that, continued to receive this money, that would be a different case, because you can then say, well, there is conduct on him that could have prevented these unauthorized payments. None of that exists. The only culprits of this unconstitutional conduct who speak loud about legality and rule of law are the very perpetrators today who are asking for this payment to be made. And given that it's the state, there has to be a higher bar in assessing the state conduct towards a single individual. Because it's not even suggested that the state was somehow unconstrained in understanding its basic responsibilities. And I'll get, my lord, right at the end of my submissions, I'll get to looking at how the state addresses us. And I say us, I include myself as counsel for Mr. Zuma and Mr. Zuma, in very disparaging terms, in terms that are unseemly, for the state which has acted unconstitutionally to come to court and say, and try and create this impression that Mr. Zuma is a constitutional delinquent who must be settled, must be made to pay this amount of money, is mean. It's vicious. I understand the DA. The DA can do that. They have a political gripe against Mr. Zuma. But for this state, who function under a constitutional regime, it can't be just and equitable to say, well, now you've produced the bill. And what is this bill actually, my Lord, what does this bill actually show? It's payments made by them, which the court said they shouldn't have paid, unauthorized payments. So I'm asking the court to seek refuge in the Supreme Court of Appeals interpretation, or what appears to be its interpretation of this so-called repayment order. When they say a just and equitable order may just be, may, perhaps, they use may and perhaps in the same sentence, may perhaps be a just and equitable order. And then they go further and they say, yes, there is a need to vindicate repayment of costs. A repayment order may well be essential to prevent abuse of public resources. But again, who has abused public resources in this case? Is the very person before your lordship asking for Mr. Zuma to pay the 28 million? Because if they had not paid this amount of money, which the court condemned and said they are luxurious payments, if they had paid attention to their duty to guard the purse, the public purse, Mr. Zuma would not find himself in this position. So the reason why, my Lord, I wish to ask for your Lordship to reinterpret these orders, to give your Lordship the permission, sitting as this court now, to look at whether it is just and equitable for the state, the perpetrators of unconstitutional conduct, to come and demand this payment. And I'm asking for the court to do so against the defenses he's raising. It's not a relitigation of the issue. And in saying it's a relitigation of the issue, actually none of these arguments have been supported at all by reference to what was argued in the High Court and what was found by the High Court. The High Court had two things to deal with. It had the issue of delay, unreasonable delay, took much of the judgment, and then it had the statutory interpretation part, which was the significant part of the judgment. There was no estoppel issue raised. There was no, we raised all those defenses, yes, but the court never dealt with them, because in relevance, the issues were confined to those two issues. Was there a delay in bringing out, in seeking to review and set aside these payment orders? And here is the other issue, my Lord. This caught me. It's a moment where the light bulb comes up like that. These very applicants today were with us in the High Court, justifying the very issue that they now call unconstitutional conduct. Referring as a reference to, or rather an order which they say is going to vindicate unconstitutional conduct. They came here in court. They argued that they gave correct advice, that this was a practice which was generally there. The legal opinions are there. They are there. It's an unseemly legal situation. That just shows how law can be used in an oppressive manner. It is entirely oppressive for the state to conduct itself in a constitutional manner and then come to court and berate Mr. Zuma for raising defenses that are legitimate to raise in the context of the facts that cannot be disputed. It's one thing if the state, and this was open for the state to actually do, because if one looks at the order, in paragraph 88D, which your Lordship we've been debating, this court order in paragraph D does not say Mr. Zuma, or does not say the state must recover this from Mr. Zuma. It's the order. I understand that if you read it in context with the judgment, the person against whom the repayment is if you read what the Supreme Court of Appeal says about the high office, vindicate the rule of law, transparency, especially by a former incumbent of the highest office in the land. I mean, without finding that Mr. Zuma was responsible for this unconstitutional conduct, it's just wrong for this court sitting now as a court that must engage with the injustices of asking a citizen to pay 28 million from the state that made an error of law. That cost him a lot of money. So all along, Mr. Zuma and his lawyers, and I wasn't there, my lord, so I'm not, I didn't benefit from that. I was not there, I must be very clear. Those who were there are no longer here. But they came here with the full armed, with the full protection of that state facility. When the DA and the EFF challenged the decisions of the state, there were two options available to the state: to relook at their decisions and to do what is called a self-review. And to say, look, we've really looked in the context of the challenges that are coming to us, self-review, we think we were wrong. No, they didn't do that. And Mr. Zuma took refuge in that. Said, okay, they're standing on their position. Today, they are the ones accusing Mr. Zuma of, they are now, today, they are asking for Mr. Zuma to be settled with a 28 million bill on the premise that to do so is to vindicate the rule of law. What is, against Mr. Zuma, what vindication of law are you vindicating? Mr. Zuma is a victim of unconstitutional violence. And so, my lord, the defenses we have raised are in the context of that debate. So I will argue on the assumption that your lordship is open to considering whether my argument, which is that you can relook at whether this payment, our order they're asking for, is just and equitable. So, and you will see, so the state attorney and the president and the presidency, they contend that courts have been, being the High Court and the SCA, have ruled definitively on the payment obligation. But as I pointed out, that payment obligation, as far as they're concerned, targets one individual, Mr. Zuma. That's the target.
Well, they've chosen.
They've chosen Mr. Zuma, yes.
But isn't the position that if there are a number of parties who are, or may be liable, that the creditor can choose which one to take action against?
Yeah, no, I mean, that's the tried principle. I cannot contest it.
So although the order doesn't specifically say take action against Mr. Zuma personally, you've alluded to the wording of the judgments, which made clear that he was a beneficiary of this conduct. Yeah. In paragraph A.
Sorry.
Paragraph A.
But my lord, even on the premise that he's a beneficiary of this unconstitutional conduct, the question you still have to ask is it just and equitable for the perpetrator of this unconstitutional violence to then ask for, having committed that unconstitutional conduct, to then turn around and say, pay. I can choose you of all the people that are liable. The people that are liable for this unconstitutional conduct, if you wanted to apply what the PFMA says about the recovery of unauthorized payments, would be the state officials who are responsible for that decision, would be the presidency. They could recover this money from a number of people that were beneficiaries, including the attorneys, if the belief was that even the attorneys, and there is somewhere in the answer, in the replying affidavit, where they say, well, Mr. Zuma should have checked if this payment were lawful with his seasoned advocates. Mr. Zuma, on being told by them that it's okay, we can pay this. Now they're coming back to this court and saying, well, you know, you say we as the state officials who violated a number of PFMA provisions by authorizing these unauthorized payments. We know those officials that triggered these unconstitutional payments. They are there. Their names are written in black and white in English. They are everywhere. But we're going to choose just one person who was a beneficiary and nothing to do with this unconstitutional conduct. And as I've submitted, my Lord, if at least there was an allegation that Mr. Zuma was complicit, which they tried to raise in their replying affidavit. Mr. Zuma was complicit in this unconstitutional conduct because other than just being an innocent recipient of this money, he should have checked with his seasoned, they use the word seasoned, lawyers, whether this decision of theirs to pay him, to pay for his legal costs was lawful. And that would have mitigated, according to them, the legal risks of making these decisions that they were making.
Yes, I'm not sure that that's a good argument on their part if they were still trying to justify their decision for a full court.
No, that's how they respond to Mr. Zuma.
Yes, now,
yeah.
But then, if until the 11th hour, they maintain the legality of the decisions.
Yes.
It rings hollow to now say Mr. Zuma ought to turn back the clock and ought to be telling us we were wrong. That is so, my Lord. But then they say the confusion in the approach of the applicants with respect, my Lord, is manifest when they say in paragraph 29 of their heads of argument, the only aspect left is an order by the above honorable court ordering Mr. Zuma to repay all the money that was paid by the state on his behalf in respects of legal costs that were incurred by him in his criminal prosecution and other ancillary applications. Now, they are asking for a repayment order. It's a repayment order they're asking. And you can have a look at paragraph 29 of their heads of arguments. That's the only aspect they're here for, to ask for a repayment order. So this means that there is no such order yet, and the question remains a matter justiciable in this court. The question being, is it just and equitable for violators for violators of the Constitution, for the perpetrators of unconstitutional conduct, to ask for this this individual for this amount of money? They have the money now, the figures that they are now asking this court to say, this is the amount Mr. Zuma pay. They themselves interpret the order to be a repayment order. But my Lord, let me make the following incontrovertible and common cause propositions, the basis on which Mr. Zuma's legal defenses should be assessed and determined. As common cause, the High Court reviewed and set aside the decision of the state to conclude agreements with Mr. Zuma for the provision of state legal costs. The court found that the state had agreed to pay the legal cost of Mr. Zuma based on an error of law, in that the state believed that it was authorized to pay this amount of money. And one understands that. The moment that was put into question, as far back as 2009, when a DA member raised it in court, the judgment refers to it. A DA member raised it in Parliament. Who is paying? How much money is being paid? The moment it was raised, the state ought to have been alert to the fact that there was an unconstitutional, unauthorized payments of state money. So we know that the court has now found that the state should not have paid these legal costs. There is no finding anywhere in the judgments, both the Supreme Court of Appeal and the High Court, that Mr. Zuma was responsible for this legal error or for this unconstitutional payments to him, or that he acted unlawfully in any way, that he used his office, abused his office, or abused his political connections, or kicked Mr. Choe to come to this conclusion that these payments should be done. Well, Mr. Choe may not have been there at the time. But, sorry, my Lord, it's unfair for the state to then come in this courtroom today, muddied, literally carrying, saddled with the findings of two courts that says that they are perpetrated an unauthorized payment
which they defended, to say in their replying affidavit, in paragraph 16.5.2 at page 00421, they say it is improper for counsel, that's me, to act for a client in respect of a claim or defense which is hopeless in law and on the facts. When did this bright moment come up? And then on page 00422, they continue, they say, a necessary correlative is that counsel must properly research the law and insist on adequate factual instructions. These are unfortunate remarks made against counsel. They're entirely unfounded. They're extremely offensive. For a senior person representing the state to endorse this kind of findings is irresponsible. It's unfair to us, who are constantly being criticized for giving Mr. Zuma wrong legal advice. I know it's going to be in the paper somewhere that we were hopeless lawyers who don't know what they're doing. And now it's coming from the perpetrators of unconstitutional conduct. It's not fair. In paragraph 0422, sorry, page 0422, they say, in principle, counsel may properly conclude that a case is hopeless on the fact, though in general counsel cannot be expected to be the arbiter of credibility. And here is the thing that exasperates me as counsel for Mr. Zuma. There is an ethical obligation to ensure that only genuine and arguable issues are ventilated and that is achieved without any delay. The state, for over 15 years, were paying unconstitutionally to Mr. Zuma. They come here, they criticize counsel, they say there is an ethical obligation, implying that we're acting unethically. It is completely wrong for this to be endorsed at the level that it's being endorsed. I have great respect for my learned colleagues, and I understand that in the heat of drafting these papers, especially against my client, who draws the best from people by his mere appearance, that this may be possible, to attack not just him, but to attack his counsel. It's just wrong. And then this is what they say, my lord, which is also very unkind. They say misconduct of this kind. So we've committed misconduct. Misconduct of this kind must be assessed subjectively. The question is whether counsel genuinely believes that the case is not hopeless and is thus properly arguable. So I must sit out, briefed to advise Mr. Zuma on whether he has any defenses. Here's the advice I try and give him. The court did not find that you had acted unconstitutionally or that you influenced this unconstitutional payment in any way. That's not the finding of the court. Yes, they make remarks about you being a beneficiary, but their main attack is the unconstitutional decision. That's what they say in a just and equitable order needs to vindicate. When they say rule of law must be vindicated, they are saying rule of law must be vindicated by holding to account the perpetrators of this unconstitutional conduct. And then you will see in their heads of arguments, my learned friends for the state, they say in paragraph 4 of their heads of argument, the applicants accuse Mr. Zuma and legal team. I've never heard this. I've seen journalists who write about counsel's performance or counsel's the legal team of Mr. Zuma. They've made it a sport. But for counsel to be, for applicants who are dripping with the blood of unconstitutional conduct, to then say Mr. Zuma and his legal team of undermining the seriousness of their position and risk perpetuating a narrative that is disconnected from the legal and constitutional imperatives of this case, is just wrong. In paragraph 5, they go on again accusing Mr. Zuma and his legal team of persisting with defenses that were considered and rejected by the full court and confirmed by the Supreme Court of Appeal. And I pause here, my lord. My learned friend can, in reply, point out exactly which arguments that have been raised by us, which were raised in the High Court, that were disposed by in the High Court, and also raised in the Supreme Court of Appeal. It would help Because in the heads of arguments, I look, including looking through with my glasses, I cannot find it. Where they say estoppel was in fact dealt with in paragraph so and so by the court, it was raised by Mr. Zuma, it was dealt with by the court, we argued it, and this is the conclusion of the court. Or where we raise the doctrine of laches, this was also dealt with by the court. Where we raise the fact that the clean hands doctrine, this was also raised by us. I remember that the clean hands doctrine was raised. But here's the point. It was raised, never dealt with by the courts. Because and this is why it's important, because I see the wisdom of the Supreme Court of Appeal in saying may well be, because it anticipates that a point there would be a moment in history when Mr. Zuma would be faced with a certain bill and a demand from a certain person to pay these costs. And the question you will ask is, but why am I the one paying? I didn't commit any unconstitutional conduct. I was a beneficiary, yes. In good faith, yes. Was I entitled to defend myself in a criminal trial? Yes. But here we are accused of raising defenses that were raised and disposed of by the courts. I'm not particularly worried about that. That can be tolerated. But when we are accused, when Mr. Zuma and his legal team is accused of raising defenses that disregard the finality of judgments and the authority of courts, and here's the question, the authority of courts. We're almost accused of contempt. We're undermining the authority of courts, and we know that Mr. Zuma has been accused of undermining the authority of the courts. So the very perpetrators of unconstitutional conduct are now accusing Mr. Zuma, who has not been found to have been party to an unconstitutional action, of undermining the authority of courts. I mean, this does not belong, this is not right to litigate like this, where Mr. Zuma is lumped together with legal team, and the legal team is specifically mentioned. They say we run the risk of trivializing the litigation by obscuring the obligations imposed by the decisions of the court, which have been adjudicated and disposed of this matter. They say, well, Mr. Zuma and his legal team, they raise defenses that are a complete waste of time and are of no moment. And it's predicated on this notion that this is res judicata. These issues were raised, decided by a court. There is a court judgment that is disposed of them. And I invite my learned friend in reply to point out where in the judgment these defenses were dealt with and disposed of. These insults are unfortunate. And it's clear they are manufactured, they are raised in order to manufacture outrage. How dare you come to court and defend Mr. Zuma? Who are you defending Mr. Zuma? It's not fair. I have an obligation as counsel to stand before an impartial court. And I cannot, as counsel, be directly attacked for trying to defend my client. So I've made submissions on the directives of the court, and I've invited the court to look at these directives as directives that require this court to engage in a new analysis of just and equitable under section 172(1)b, yeah, and to ask the question whether Mr. Zuma is entitled within the context of that particular doctrine or that particular principle in the Constitution to find that the just and equitable order is not just to order Mr. Zuma or not to conduct an inquiry into the conduct of the state in respect of these payments, but hold accountable the perpetrators of unconstitutional conduct. Because your Lordship, we raised this in our papers. I think it's answering affidavit, and I can lift it out in the papers at some point. What the state did was to violate every known law and in financial management, of state financial management, which is governed by the state, the preferential procurement, the Public Finance Management Act. There are consequences that the Public Finance Management, the PFMA, sets out for officials who act in this manner. And a just and equitable order would direct them to do that.
But they were party to the proceedings.
No, but what the court is now doing is looking at a just and equitable order that remedies the unconstitutional conduct. And if your Lordship accepts that the violations were PFMA violations, they were not Mr. Zuma's violations, the perpetrators of this unconstitutional conduct are the ones who should be held accountable. And when we're talking about accountability, which is what the Supreme Court of Appeal raises, it says that abuse of public resources vindicate the rule of law and reaffirm the constitutional principles of accountability and transparency. It's not just putting a statement of how much money was paid. It's also asking who did this.
You say the relevance of Mr. Zuma on the basis of the thesis that you put now, you mentioned in paragraph 88, is only by virtue of the fact that the legal services that were rendered for his benefit. That's his involvement.
Yes.
No wrongdoing on his part. That was
none.
An issue. He didn't influence anybody. It was a mistake of the state. And yes, he may well have been a beneficiary, but if it's found that the actions of the state are unlawful, you say that should be the first port of call for restitution and not Mr. Zuma, who through the passage of time and quantum has himself now been placed in a invidious position.
But I could say it better than you have. And if it appears in the judgment, I'll be very happy to see that kind of.
There's a lot of material. I'm just to make sure that I understand your case.
And it helps me because you do.
Yes.
Yeah. That's exactly that's the crisply put. I would sit down after that understanding of the case.
That's just that I understand what you say.
Yes.
I think you must deal with all of it.
Yeah, no, I will. I intend to. So ultimately, so when one looks at then the order, and one must interpret that the 88D to say to the state, once you've compiled this, go further and recover this money. The question of who must recover the money. The order, in my view, was wide enough for the state to say, okay, fine, how do we correct this? Because it must have been clear to the state, including to the DA, I'm sure, that in the passage of time of maybe 15 years, 20 years, this money had been accumulating interest. This money, Mr. Zuma labored under the impression that if the contract of the agreement had been upheld, all he needed to do was to make sure that he wins his case in the criminal trial. That's all he needed to do to ring-fence himself against repayment. But now he has not won the case. The case is still ongoing. He has to immediately find 28 million over and above finding new money in order to pay his new legal team. So I'm saying the law gives us a remedy where the state officials have violated the PFMA. The law gives us a remedy. And it was open to the state to say, we've compiled this, it is us who were responsible for it, there are officials in the state who perpetrated this, we are going to recover this money from them because they should not have done this. Of course, they have defenses themselves if they were to be placed in that kind of position. Or even to go to the state. And I mean, the other thing, my Lord, which just, I know there's an answer that has been given by the state, is that when this report was compiled, or when this order was made, the order of the High Court, There's nothing that says once they have compiled this schedule of payments, Mr. Zuma must be allowed to comment on it, on them. The taxation of those costs. Look at the invoices. Look at how counsel or how attorneys charged in that matter. Let's do all that. I know they say that we were given that opportunity when the affidavit was filed. I understand that. And we didn't respond. I understand that. But I'm saying the court order itself didn't go far enough to say to the state, once you've done this, give Mr. Zuma a hearing so that he's able to look at this cost himself and say, okay, Mr. Bofu was charging 100,000 a month. Sorry, an appearance. And that was wrong.
But isn't that what these proceedings are about? So yes, all the vouchers, yes, you received the letter with the demand. Now it's the defense or the challenge, apropos the quantum, it should be raised now.
No, my lord, but
you just said, oh well, there it is. You haven't undertaken that very process. And now these proceedings would have been an opportunity to do that at your client.
No, but what is clear is that the process to hear was already court managed. So you'll see that the order says the state is directed with 3 months to file a report under oath, supported by accounting detailing the steps that it has taken or will be taking to recover the amounts paid by Mr. Zuma. Nowhere does the court say the state, after compiling this and providing this information, must then go to Mr. Zuma's attorneys, including the attorneys who were parties to this case, to say, here is the bill that the court said we must look at. Can you comment on the bill? The court order does not direct that. So if strictly acting on the court order.
Yes, well, on the basis of the attorneys, they would have submitted invoices and counsel would say, well, that work was done. It wasn't the issue on their part whether the work was done because there was an invoice and a payment. Those match up. The inquiry on whether there was fair value for what was invoiced as against what was paid, and which may well have resulted in a reduction, was something that, having now decided that Mr. Zuma was the party against whom they wanted to pursue payment, was for Mr. Zuma now to exercise that right.
No, I readily accepted, my lord, that in their replying affidavit to our complaint that there had been no opportunity given in terms of the court order. There had been no opportunity given to Mr. Zuma to look at this report together with his lawyers, to have the taxation process initiated if it was necessary to do so. In fairness to the answer is given. We prepared an affidavit. We served you with the affidavit. It was up to you to decide how to deal with that affidavit. But the court order does not give Mr. Zuma any right of reply. So if they are acting in terms of the court order, we provide a reply, and they say, well, but the court order says what it says.
You don't engage with the specifics of how the 28 million is computed.
No, we don't engage with it because we're not directed to do so. The state was directed to do so.
No, but once somebody serves process upon you and says, pay me, you must pay me 28 million, and it's been quantified as follows. As a litigant, you have the right to say, well, there may be a court order which says I've got to pay you, but it's not 28 million. Look at A, look at B, look at C. There's an additional error. There's an additional error here. There's that error there. Whatever the case may be. To say, well, I wasn't invited to have a discussion about the consultation process. I'm not certain that.
What is correct? Sorry, my lord, but I have a feeling you've finished the comment you're making.
No. What I wanted to add on to it was, but I hear your point with regards to that the order of report wasn't specific enough. It seems to me that perhaps Mr. Rosenberg's client probably recognizes that, hence the
augmentation,
going where it does to make sure that perhaps there's oversight or confusion intervention in the event that I'm with them to make that request.
Yes. No, I understand. So, Milord, I'll take it no further because I think what you've said covers my submissions. But a tried principle in assessing whether the repayment order must be met is that Mr. Zuma was entitled to a lawful decision by the state, by the president and the state attorney. That's a tried principle. He was entitled to a lawful decision on the issue he had raised. When he asked for state legal assistance by way of a cost order, he was not asking the state apparatus to act unconstitutionally. He was not doing that. He was saying, look, engage with your legal obligations and your protocols and your regulations. And if you find that I'm entitled to this cost, pay me or pay my lawyer so that I'm defended. So he was entitled to that. When one considers a just and equitable order, that principle is very important. What was Mr. Zuma entitled to? A lawful decision. What did we have? An unlawful decision. What were the consequences of that unlawful decision? 28 million. If we take the DS argument plus interest and with the risk that the other consequences may follow. My Lord is very aware our courts have developed the scope of the judicial discretion engaged when a court is determining what a just and equitable order is. And that reinforces what the Supreme Court of Appeal said about this particular case, that a repayment order may well be essential to remedy the abuses of public resources. And can I maybe peg this for a moment and engage with it? When the Supreme Court of Appeal says a repayment order may well be essential to remedy the abuses of public resources, against whom is that order that directed? It is against those who abused public resources. And who abused public resources is the applicants. When specifically challenged about the lawfulness of that decision, what do? They defend it. They could have reflected, gotten another legal advice from other counsel. They could have really mitigated their risks. So that order must not be regarded as the Supreme Court of Appeal saying the abuses of public office in relation to public resources in respect of Mr. Zuma. This presupposes that a finding that Mr. Zuma abused the public resources. This finding by the Supreme Court of Appeal does not presuppose that Mr. Zuma abused public resources. It is not making that finding. The Supreme Court of Appeal is not making that finding. It is simply saying it's important that unconstitutional conduct is corrected. It may well be that a repayment order is made to prevent the abuse of public resources.
But you say that if there is to be a repayment order, in the first instance it should be against the specific individuals whose wrongful conduct has given rise to the order.
Yes.
Meaning the officials the legal officials who gave the wrong opinions.
Yes.
Who affected authorized payments or whatever the case may be.
So essentially,
Mr. Zuma's not first in line to pay back the money, as it were. He's last in line. The wrongdoers must be pursued first.
I'm taking it further, my Lord, because I'm suggesting that a just and equitable order would excuse Mr. Zuma from payment. I'm saying Mr. Zuma's, I'm taking it way further. A just and equitable order will recognize that when the court was criticizing the state's unlawful and unconstitutional decision, it was not criticizing Mr. Zuma. It was criticizing the state. So we know the court did not find that Mr. Zuma was responsible for the decisions of the state, or that he was somehow negligent or somehow blameworthy, or that Mr. Zuma failed to take the necessary steps to ensure that the public resources that were being expended on him were not expended. Even though the court finds that there is a luxurious scale of litigation, it's really based on the fact that the custodians of public funds were not paying attention the court does not find that Mr. Zuma was reckless, corrupt, or irresponsible.
You say that the way in which the litigation was conducted is actually beside the court.
Yes, absolutely.
Because
it's only relevant. Sorry,
the
Mr.
scale at which someone litigates is often linked to the availability of resources. Those who have very deep pockets can litigate very luxuriously, and it's of no moment
Yes.
from their own pocket.
Yes, I know it doesn't sound right, my lord, to put it the way you put it, but I'm saying the custodians, because he was not litigating from his own pocket.
Yes, but what I'm putting to you is that whether it was luxurious or not is irrelevant. It's the fact that it ought not to have been paid for.
Absolutely,
so,
is.
And whether it's like that's a value judgment.
But also, my lord,
which is not bears no momentary. It's relevant possibly to the amount, but it's not.
Only if maybe another view to it is that it would only be relevant if the duty to safeguard these funds that were being paid had been properly safeguarded. In other words, when you're looking for liability, and you're saying, why are we here? Why do we have? Because the unlawful conduct has cost the state 28 million in public funds. So, but ask the question.
So you say it's another element of the blameworthy conduct of the state.
Yes.
That besides agreeing to pay when they ought not to have done so, they then paid without proper supervision and control over what was being paid, and that is why you now find an outstanding amount of credit.
But that it is when the court looks at the just and equitable order to make, that it takes into account that. So a trial should actually be the state's conduct, not Mr. Zuma's conduct. And Mr. Zuma was not found to have acted unlawfully and all that. But let me just elaborate the just and equitable, the principles that underpin a just and equitable order. Your Lordship is aware of them. They are tried, they've been raised in many cases. But the starting point really is finding that there has been a violation of PFMA provisions and unauthorized expenditure by the state. Right. There is a recent judgment actually, I mean, it's Sikoko Manager Incorporated Attorneys versus Fatahomo towards a local municipality. Lord, I will give the full citation of that judgment. But in paragraph 9 of that judgment, it says it is incumbent on a court making an order of invalidity under section 1721A to then invoke the provisions of section 1721B in considering whether or not to make an order which is just and equitable. And then it criticized the court and said the court did not do so. And this judgment is a Supreme Court of Appeal judgment, my Lord. It's and then paragraph 14 of that order. What had happened here, my Lord, is that this firm of attorneys had provided legal services to the municipality. And the municipality took the view that the services they'd gotten from the municipality, although acceptable, the procurement process was unlawful. Especially the extension of the contract after a particular point where the contract had ended. There was an extension which the municipality took the view that this particular extension was unconstitutional or unlawful. They took the matter to court and they wanted to review and set aside, refusing to pay the law firm for the amounts of money that were being paid. The Supreme Court of Appeal said, the High Court said you should pay them, and the Supreme Court of Appeal endorsed it. In paragraph 14 of that judgment, it says it is common cause that the municipality has never complained about the effectiveness of the respondent services Undoubtedly, the municipality received the full benefit of such services. Most certainly, Sekoko attorneys incurred expenses to enable it to render the services to the municipality. The municipality did not dispute Sekoko's entitlement to be paid for services rendered. So the court essentially looked at, even if the municipality had been correct to say that the appointment was unconstitutional, they nonetheless had to pay the work because they benefited from the services of the attorneys. My Lord, that judgment is 2022 ZASCA 28, and the paragraphs is, as I've mentioned them, is paragraph 9, 14, and 15. And then the STINCAP is an old case of the Constitutional Court. I think we all have referred to it, if I'm not wrong, but to the extent it's not, it's a 2007 volume 3 SA 121 Constitutional Court at paragraph 29. It's the STINCAP versus Provincial Tender Board of the Eastern Cape. It's an old case. When one assesses this, the directive to take all necessary steps, including the institution of civil proceedings to recover the amount, have regards to what the judgment says about an appropriate remedy. And it says in 29, it goes without saying that every improper performance of an administrative function would implicate the Constitution and entitle the aggrieved party to appropriate relief. In each case, the remedy must fit the injury. The remedy must fit the injury. What is the injury here? The injury is the unconstitutional payment of money. That is the injury. The remedy must be fair to those affected by it and yet vindicate effectively the right violated. It must be just and equitable in light of the facts, the implicated constitutional principles, if any, and the controlling, if any, in the controlling legislation or law. It is nonetheless appropriate to note that ordinarily a breach of administrative justice attracts public law remedies and not private law remedies. The purpose of public law remedy is to preempt or correct or reverse an improper administrative function. Some instances, the remedy takes the form of an order to make or not to make a particular decision, or an order declaring rights, or an injunction to function reasons for an adverse, to furnish reasons for an adverse decision. Ultimately, the purpose of the public law remedy is to afford the prejudiced party administrative justice, to advance efficient and effective public administration compelled by constitutional precepts, and at a broader level to entrench the rule of law. Now, this would ordinarily be directed at state functionaries who have committed unconstitutional acts. And there's the Bangwenyama judgment, your Lordship is aware of it, paragraph 85 of that judgment also deals with what Justice Forleman then said. And it does acknowledge that this position where even after finding that there's been unconstitutional conduct, the functionary was committed unconstitutional conduct, nonetheless, just an equitable order does not necessarily have to result in money being paid back. And he says the apparent anomaly that an unlawful act can produce legally effective consequences is not one that admits easy and consistent logical solutions. But then the law is a pragmatic blend of logic and experience. The apparent rigor of declaring conduct in conflict with the Constitution and PAJA unlawful is ameliorated in both the Constitution and PAJA by providing a fair, a just, and equitable remedy in its work. So, and then he says, I don't have to set out what that means because it's wide enough. And your Lordship also is aware of the State Information Technology Agency versus Kijima, the Kijima case. In paragraph 54, it also deals with a just and equitable order. But in many instances, and if your Lordship engages with these cases, you'll find that there was an unlawful administrative action taken, a company performs the work, money is paid, then later on the state decides, oh, we were wrong. And at some point the Supreme Court of Appeal said, no, this kind of behavior must be looked at carefully because the state behaves badly and then seeks the court to correct this unconstitutional conduct. It's all usually for audit reasons. But the Supreme Court of Appeal said you must watch this kind of conduct, where the state does this kind of thing all the time. But it's not always the case that upon a finding of unconstitutional conduct, the appropriate remedy is paying back. And there are many cases Your Lordship would be aware of in which the courts did not immediately order or did not order the payment of these. And I want to be a little selfish and refer to only one case which I got recently as I was preparing for this, and Your Lordship will bear with me. It's the Greater Zanin Municipality versus Bravo Span. It's a CC, so it's 2002, ZASCA 155 at paragraph 16 to 20. But I just want to read one paragraph in that. I'd commend Your Lordship to look at paragraph 16 to 20. But the one paragraph that is very important, which I even marked here, read, is this one, which says, Bravo Span was not responsible for the unconstitutionality of the extension agreement. On the contrary, the municipality in the circuit allayed its concerns. So when Mr. Zuma is taken to court and is told, hey, you know, the money you're carrying is hot, and he says, but why? The state comes in on board and it says, no, we did the right thing. Until the court says, no, you did the wrong thing. So this case really is the principle in 2022 would fit the conclusion that we are seeking, which would be that even though the just and equitable order is not to saddle Mr. Zuma with the payment obligation of this 28 million. Within the context, and this must be understood, my Lord, that we've raised the various defenses within the context of debating a just and equitable order. What is a just equitable order in circumstances where the party seeking to enforce that order has unclean hands? And one must then look at what the clean hands doctrine says. And the clean hands doctrine says that a party who is seeking the intervention of the court cannot have or obtain such intervention or assistance if that party has acted unethically, negligently, and wrongfully in relation to the subject matter of the lawsuit. Classical.
Mr. Chair, they're not acting of their own accord. They're acting in terms of court. So does that really apply?
No, how it applies, my Lord, it's got to be seen within the context of what the court order says, but sort of what the judgment in terms of or that gives rise to the court order says.
Except that if they are correct in their understanding of the documents and the position they've taken, then they're acting in accordance with the judgment. They're not on a frolic of it. They're doing this unwillingly, in fact, because they were working in the court of the full court.
Yes. But this must not be ascribed to my learned colleagues.
Yes.
No, not at all. This what I just said here is not.
Yes. But even the state itself.
The state is a different position, and this is why Bravo Span is important, because where it's clear that the state has acted unlawfully, has acted negligently, and here at best we can say they acted negligently. At best we can say that the state acted wrongfully. And the clean hands doctrine would find application in that particular scenario. But the second aspect is having the principle is really that he who wants a remedy or who wants a remedy must have clean hands to attract the court's attention. In this case, we know that the courts have been told, the applicants have been told by the courts that they acted unconstitutionally. But further than that, and this court can actually make those kind of findings, The applicants violated the provisions of the Public Finance Management Act. We make that point in the answering affidavit and in our heads of arguments in paragraph 33. And we set out those provisions that have been violated. The law tells us exactly what the remedy is for a breach. The Public Finance Management, it tells us what the remedy is. And that would not point towards Mr. Zuma. My Lord, I would then have looked at a number of cases that have dealt with the Clean Hands Doctrine. I don't intend to traverse this. We comprehensively dealt with those, both in our answering affidavit and in our heads of arguments. They stand as they are, and we'll stand by what we've said in those submissions. The principle really is that when you're looking at a just and equitable order, you ask yourself the question: who is asking for this order of repayment for against Mr. Zuma? Who is it? It's a party that acted unconstitutionally. And how does the Clean Doctrine, the Clean Hands Doctrine apply in that circumstance? Is it just and equitable to grant an order of repayment to a party that has got this, which suffers from this kind of, which suffers from this kind of, I'd call it infirmity, unclean hands. Essentially, they have unclean hands as they ask for the orders against Mr. Zuma.
That the interpretation that the applicant must ascribe to the order of the full court must be one that is benign as far as Mr. Zuma is concerned, because of their own involvement in authorizing and assisting with the position even before that court.
Yes.
So it's not that they've undertaken this process for any motive, as one would ordinarily argue in an unclean hands situation. Here they're compelled by order of court to do something. No. They've interpreted it in the particular way they have. You say that is where the interpretation lies. That properly considering their own position and role in this matter, they ought to have looked elsewhere. And you then bolster that argument by saying that the specific wording of the order, paragraph D1 and D2, doesn't say Mr. Zuma must pay back the money.
Yes.
It leaves it open for the state attorney to look to see where the responsible parties are.
Yes.
And to then pursue those parties. You say the correct path to have followed, at least in the first instance, was to proceed against the officials concerned and to discuss them, and only after that, possibly, although you argue that it should in fact never happen, you say Mr. Zuma is completely innocent here, he's a victim of their wrongdoing, but he would be the last in the queue if he was in the queue at all.
Yes.
On the reading of the order in the way that you,
yes.
That you contend to.
Yes, yes, my Lord. I think you've summarized it as they have a different view.
They read it in a different way.
Yes.
Yes. So it's in essence going to come down to the terms of the order.
Yes.
I think you quite correctly highlighted that both judgments, the judgment of the Supreme Court and the judgment of the Supreme Court of Appeal, have to be looked at very carefully to see in which direction they point in terms of the interpretation of the order.
Yes. And my Lord, and the PFMA should not be lost in just to supplement what you've just said. The PFMA provides us with a remedy. So if they started off by saying, okay, fine, the court has found that we were wrong, who must we hold liable within our own system who would trigger this, right? And they look at the PFMA for a remedy. And of course, and when I say that Mr. Zuma should be far in the queue, I appreciate the fact that there is a benefit, and it may well be that that benefit attracts a certain level of accountability. But the fact of the matter as his counsel, I cannot argue that he should be held liable at all, based on the arguments I'm submitting, that the state was essentially coming to the court with unclean hands. And just to correct something, my lord, I'm not sure that the clean hands doctrine requires motive, requires that you have there's a mindset of wrongdoing. I think the clean hands doctrine extends further than that, I can refer your lordship to the City Council of Pretoria versus Walker. I refer to that case in paragraph 47 of our heads of arguments. That just conduct of government official, it doesn't have to be intentional. It can be negligent. It can be, it can be just wrong in the most inexplicable way. You don't take legal opinions. You don't take risk mitigation measures before you take a decision. And that case, the Walker case, was really a case about state conduct against denizens in the city of Pretoria.
You say page 47?
No, paragraph 47.
Paragraph 47.
So, and you'll see at paragraph 47.1 we summarize the two constitutional issues at stake were whether the legislation that imposed higher service levies on the so-called formerly advantaged communities constituted a violation of their right to equality, and or whether the conduct of the council's officials in only collecting levies from the so-called formerly advantaged community violated their right to equality. And the clean hands doctrine was raised there, and the court had particular comments to make on that doctrine. I deal with that. We deal with that later, further down. My lord, I do not want to because the comprehensive heads have been provided on the clean hands doctrine. So our conclusion is that when you're determining whether it is just and equitable to order that Mr. Zuma pays this 28 million, you consider whether the asker, the requester of that order, does not suffer from this particular principle of clean hands doctrine. My lord, I see it's 1 o'clock.
Mr. Masuku, without the meeting you have, how much longer do you think you're going to have?
Oh my lord, we have tomorrow, so I intend to go until 4. And then, no, I'm just really joking. I think I'll probably be, when we're back, I think I'll probably be 30 minutes, 45.
Okay, so if we take a 30-minute lunch adjournment, then we ought to be able to accommodate you
and the others.
Then the replies.
Yes.
Okay. So we'll adjourn until 25 to 2.
It's the court business. Thank you, my lord. My lord, I will similarly stand on the submissions we make on the principle of estoppel. I'll stand by what we say in our heads of arguments, and really just to say that the question always that should engage the court is it just and equitable? Under these circumstances where Mr. Zuma relied entirely on an expectation that the state would act lawfully to then turn around and saddle him with this extraordinary bill. Because just really the highlight of it for me is a simple proposition. The unlawful state conduct cost 48 million of public money.
28.
Sorry, 28, sorry. We could increase it. Sure the DA will want that 48.
But if one accepts that the legal services were rendered to that end, and one must accept that the state attorney would have checked that those invoices were in order and the services were rendered. The services were rendered.
No, the nice
thing. What the case
thing
really turns on is that you say, if one accepts that people behave in a consistent manner, that had the state attorney refused to fund the legal expenses, those expenses would have been paid by the President directly on an as-and-when basis spread over a 15-year period, as opposed to now finding himself with a lump sum plan.
yes. Yes. So the state action cost the state firstly 28 million. Secondly, is now costing, if this order is made, it would cost an innocent party 28 million.
No, but why would it cost him 28 million? If one accepts that he would have litigated in the same way anyway.
No, you can't make.
You can't. It doesn't help you, and I'm sure you don't want to argue that if he'd known that he had to pay for the litigation out of his own pocket, he would have litigated in a different way. Because that's the case that the DA makes out and the DFF made out originally, that this was a frenzy.
No, we've accepted that the manner of litigation is irrelevant.
Yeah. But he would have litigated nonetheless.
Yes, but what I'm saying, but we've accepted that how he would have litigated if from day one he had been told, no, we can't do that. It's just simple speculation. It has no relevance at all how he would have litigated. But what we know is that because he had the protection of the state, he litigated as he did. I'm not sure, my lord. I want to be, because we deal with these things quite extensively in our heads, and to be honest, when you said you had read your heads, you had read our heads, which I believe you have, it just seems to me to be the finesse of an advocate is knowing what to argue.
Well,
and I can say that we stand by what we've argued.
Perhaps if you want to truncate it, if there's any specific points on any specific defense that's raised that you haven't already covered, you may that's what you would the main contention, so that at least they covered it. As to the specific content, I have the read detail and we'll have
I know perhaps let me just deal with what the DA's arguments before. I think I will simply stand by what we've submitted in our heads of arguments as far as our case is concerned. But to then address the arguments of my learned friends for the DA, for the applicants and the DA.
Yes.
My learned friend started off by looking at the delay in bringing proceedings, and he said, well, so what? The case is ripe for hearing. Let's get on with it. But when the court assesses a just and equitable order, it must look at all those variables. It must look at state conduct and asks itself, it's delay that is not justified by the state. Whose response is, yeah, I can give you an elaborate reason why there was this delay. And there are many reasons. But let's get on with it. It has a bearing on the court's assessment on what, because they have not assessed how that delay impacts on other people that are involved in the litigation. And that's why the DA is here. The DA is now playing the role of an overseer of the state conduct, because it accuses the state of being untidy in its execution of duties. So, and then so I would say that the delay is relevant in looking at whether it's just and equitable for the state, which has behaved this way. And one has to take it from the fact that there is this order of unconstitutional conduct, and on and on and on. Now there is the delay, which is in executing a judgment of the court, and they are not giving reasons for it. And now they are there, and then of course the fact that they come here and then they accuse Mr. Zuma of all sorts of things that he is not. In the DA's case, what became clear is this. Oh, just another remark, which responds to the applicants before I go to the DA. I will convey to Mr. Zuma their sympathy towards him, because the argument was we are not unsympathetic to Mr. Zuma, but if 28 million is ordered and plus the interest that they are seeking, that they are not opposing from the DA, well, the rule of law must prevail. How can it be right in the same mouth to say one sympathetic to Mr. Zuma, who did nothing other than be a victim of the unconstitutional conduct in receiving money that was unconstitutional? At the same time, we are not opposing the DA's request for extrajudicial orders. But coming to the DA, Mr. Sean Rosenberg, my colleague from Cape Town, starts off by referring to the orders that were sought in the High Court. And he correctly refers to paragraph 16 and 17 in these, which they are set out in the Supreme Court of Appeal orders, those orders. What was sought by the DA in the High Court was not granted by the High Court. Sorry, my lord, I just my eyes. So what was sought by the DA in the Supreme Court in the High Court? The DA wanted in paragraph 16 they wanted that Mr. Zuma is directed to pay to the National Treasury and all such amounts that the state has paid towards Mr. Zuma's personal legal costs as a result of the decision referred to above. Now, if the court had dealt had said, could notionally have said, could have granted this order. And only issue before would have been the amount. But the order is given that he must pay, and the state is directed to compute that amount and to issue Zuma with a bill for Mr. Zuma to pay. The DA did not get that order. Similarly, EFF did not get its order that that relates to the payment with interest. Am I right? Yes. It's on page, yeah. It's paragraph 17. Within 6 months, Mr. Zuma and Hali, liable jointly and severally, shall repay the amounts of the impugned payments plus interest at the prescribed rate, calculated from the date of it. The court did not engage with all these issues, and similarly, the Supreme Court of Appeal did not engage with these orders. So what then happens is that the DA, having and this position in the High Court was not appealed by the DA. It was not appealed by the EFF to the Supreme Court of Appeal, in the sense that when they didn't get the orders they wanted, and they felt aggrieved by that order, they would have appealed ordinarily to enforce those orders. So what happens is that they then, they've come to this court to seek to augment the High Court order. In other words, they want your Lordship to then vary specific enforcement, what they call supervisory orders to be made, which augment the High Court order, which vary the High Court order, and we respect that is impermissible.
Is that so?
Yes.
Isn't paragraph B2 refers to new proceedings, and the orders that are sought now in respect of the interest and so on are part of the new proceedings. They're not part of those proceedings. So whatever they may have sought it there, they didn't get it there, but now it's sought qua the collection proceedings, if I can call it that, the current proceedings.
Yes.
So it's different proceedings. It's not the same proceedings to say, well, it was implied he refused in those proceedings, and therefore it can never be sought in any subsequent
No.
proceedings.
What happened was it was sought, it was not granted.
Yes.
There was no appeal to it. What then happens is that the High Court grants an order that directs specifically what should be done. And that's what they're trying to augment. They're trying to augment by coming to this, not the High Court, not the court in the High Court order, which they could have gone back to the High Court order and said, well, vary your order. This is how you should vary it. We want these orders, interest, and the other things that they would have wanted. And your Lordships, the manner you dealt with the attachment orders they seek, I think I have no submissions to make. I think my sense of it is that sense prevailed, and we might meet that case on another day. But for now, the only issue really that your Lordship is being asked to do is to create to impose a judicial supervision of a state function of collecting money from debtors. Political party now wants the court to be involved in how money is collected. I think the court should really just leave these issues to the relevant state functionaries.
Isn't there good cause for the ordinance in the sense that, well, the state erred in the first instance in granting financing? That's a situation which persisted for many years and resulted in court order setting it aside. So the state, as you said, has blameworthiness as far as that aspect is concerned. Then when an order is issued saying do the following within a certain period of time, they don't comply with those time periods, and there's no explanation, that's common cause. we left with that situation. Is it not in the public interest that the errant state attorney, if one wants to put it in that way, and I'm not casting aspersions on any person, as the institution, that a state attorney that has had a number of missteps, that there's some mechanism to make sure that they don't mistake again. And it's a benign mechanism in the sense that the court's not going to necessarily be looking over their shoulder and giving them instructions. It's simply a reporting function, as would happen between any attorney and their client. The attorney must tell his client what's going on. In this case, the client is the people of South Africa.
Well, the argument we would make is that the only parties that are representatives, the only party that would be a representative, that is a legal duty of recovering the amount, is the state. It's been directed to do so.
There's no question about
right.
that. It's just a question of that if it's directed to do that, if that's the order that's made, that there's some mechanism to ensure that it happens, that you don't have delays as happened previously. I think that's sort of a concern. Leave aside the interest aspect, but as far as the supervisory aspects concerned. So it's directed at the state attorney and simply to ensure that if something is already to be done, that they do what they need to do within a reasonable period of time. It's not, it doesn't go beyond that.
No, I understand that, but my lord, this is the problem of orders that are imposed that are imposed by what I would regard as interlopers. There's just interlopers in the case. That's why we don't believe that they have a local standing to come and ask for interest, which they asked and were not given in the High Court.
Which in the High Court they were a party.
No, they were a party, but they are now no longer a party after the judgment of the court, because the judgment of the court specifies who must be to stay, who must take what steps and where.
But doesn't the party who sought a judgment have a legal interest in the execution of that judgment?
It may well be.
Even though it's not a direct benefit to their own pocket or to themselves, but the fact that they sought an order and obtained an order in their favour, they have a legal interest in seeing it through.
No, my lord,
I haven't heard you fully on it, but...
No, I won't waste your time, my lord. I've never won this point against the DA and any of the parties that they generally allies of the DA, so I will not persist with it.
It's not a question of winning the point.
It's a point it's a very important point for Mr. Zuma.
Yes, but because I want to engage on it.
No, but I understand the legal position. It's established in many cases, so I won't be trying to re-argue a case. To re-argue a point. The point I try to make is that you've got an order that specifies who the parties must be in executing this particular duty that the court has imposed. But you've got a political party which is a gripe against Mr. Zuma that will persist in trying to humiliate him, embarrass him, and berate him, and even want his pension. I mean, it's extraordinary. It's extraordinary. That's the only interest. The only interest the DA has is to humiliate Zuma politically.
Yes, but politics...
they're irrelevant for you, but yes, I can say this representing Mr. Zuma.
Yes, but I think I can ought to take cognizance of the fact that no one is press-ganged into a political career. People enter politics voluntarily, and when they enter it, as they do with the practice of law or any other endeavour, they know the risks and they know the consequences that come with it. So, insofar as they may be agreed with Mr. Zuma and
yeah, so we will just live with it. We'll just live with the fact that
Zuma was a very prominent politician and
still is, yeah.
He's got broad shoulders,
yeah.
And I'm quite certain he can give as good as he gets.
Yes, no, but
not, the fact that they may have whatever reason doesn't detract from the legal position. The
I've made the point, the submissions, but I accept what you're putting to me, and I will not press the point. As I said, I've never won this point against them, so, but I must raise it every time we are against each other, that they must be clear that what they represent is not necessarily legal interest, but a political interest. Then we will come to the issue, I want to come to the issue of costs. The applicants should pay the costs of Mr. Zuma's, the legal cost of Mr. Zuma, whether they are successful or not. And this is for this really untidy way in which they have attacked, without any justification, practitioners, the litigant himself, and have not really accepted. Not once do you hear the state saying to the public for whom this unauthorized money was paid, "We're sorry we did that." Even to Mr. Zuma, "We're sorry we gave you this legal advice, which was wrong. It is costing you a lot of money." They want, in fact, costs against Mr. Zuma for being wrong in advising him that he was entitled to receive money. So we would ask that the cost be for two counsel on the scale they've asked for from Zuma, which is C and B. But I didn't understand the DA to be wanting any cost from us. So, but if they do want any costs, well. The real opponents of the DA is the state. We filed nothing except the notice, which raises a point. I'm quite prepared to the point about whether they have local standing to come here and ask for an attachment of Mr. Zuma's home and his pension, and to ask that the state be supervised. I accept readily that may well be that. Well, they've always gotten that the standing and the consequent orders.
You say that had the state accepting that process that's followed is correct for the purpose of the proposition, had the state done its work properly, it would have sought interest from the client, and it would have proposed the supervisory aspects which the DA has raised.
Yes, and would have dealt with it not as a separate application.
Having to only deal with one litigant as opposed to now being marked with costs of two, if I'm not with you.
I'll snatch that back in, my lord. It's a well put back proposition.
Well, it's just a proposition.
Yes, and I accept that proposition.
But is that
yes.
That's the position you take?
Yeah, that's the position we take. My lord, I've done this in order to ensure that my learned friends have enough time to respond. So if there are no any further questions, I have exhausted myself and I've exhausted the arguments I need to make. I stand by the heads and by the pleadings we filed. We abandoned none of them, except to the extent we were taking a point of the DA standing. I'm quite prepared to accept that that point will not take us any further. So I wouldn't persist with it. Thank you, madam. Oh, sorry, my lord. Can I just ask if my junior has a clever point to give me? They're all giving me the thumbs up. Thank you, my lord.
Thank you, my lord. My lord, I'd like to quote from the High Court's judgment penned by Justice Mayer, I think it was, writing for the full court. He refers to the great writer T.S. Eliot, who he says spoke of the recurrent end of the unending, and aptly quotes the learned writer because of what follows in the judgment. The litigation between the NDPP and Mr. Zuma has a long and troubled history, and the law reports are replete with judgment dealing with the matter. It is accordingly unnecessary to say much by way of introduction, and a brief summary will suffice. And then the rest, I'm sure your Lordship has read. But this is what's identified, the ongoing litigation. Now, it's common cause that Mr. Zuma was of the view that because the state is prosecuting him, the state attorney should not represent him in the criminal proceedings. Now, I want to debate this with your Lordship, because much turns on what happened then and why it culminated in where we are today. He then gets one Mr. Halley to make representations to say that there will be a conflict of interest. Now, on the one hand, criminal prosecutions are dealt with by the National Prosecuting Authority, who is an independent organization and functions under specific legislation. The state attorney functions under the State Attorneys Act and is overseen by the Solicitor General and whoever else may be necessary, for example, the Minister of Justice. Now, those are two distinct departments. They don't share information. But there's a factual and actual request. In fact, Justice Mayer records that there were 6 different requests by Mr. Halley on Mr. Zuma's behalf for funding, on the premise that the state attorney, whose act upon which Mr. Zuma relies, because Mr. Halley writes to the state attorney and he says, in terms of Section 3.1, alternatively Section 3.3 of the State Attorneys Act, I believe that Mr. Zuma is entitled to legal funding. But because of this alleged conflict of interest, which is just a ruse, that's all it was, I have been given instructions to represent Mr. Zuma. So I will instruct you as to who to pay for. Now, your Lordship and I were attorneys for many years. We know that what your client does, or rather what the attorney does, binds the client. He cannot say he didn't know who Mr. Halley was, and Mr. Halley went on a frolic of his own and did what he wanted without discussing it with him. So he makes specific demands. In one instance, he asked for an amount of over 6 million rand to be paid into Mr. Halley's trust account. And he says that there'll be 2 senior counsel, 2 junior counsel, and then an additional senior counsel who does not practice in KZN. Now, this is dictating now by a private attorney who's acting for Mr. Zuma, telling the state attorney what they want the state to pay for. How is that not luxurious? I don't understand. State resources, the state attorney would have been there. The state attorney has access to many silks and competent juniors who would have been able to appear and assist Mr. Zuma. But that is the starting point of this ongoing saga. I personally, and I don't say this flippantly, but your Lordship can take judicial notice. Mr. Zuma hasn't been paid any cost of any kind. He hasn't paid anything. In these papers, there is a judgment obtained by VBS in its former glory for over 6 million rand, a judgment against Mr. Zuma. He took the loan so that he could pay for the
Sorry, madam, I don't know. But this is totally irrelevant. Totally irrelevant.
Perhaps, Mr. Doctrine, you could just give an indication of the point you want to make.
Yes, I will, but it's completely inappropriate for senior counsel to interrupt me. This is not the USA. He can get an additional chance if he asks for it. You mustn't interrupt me. Your Lordship is in charge of the proceedings. But part of these papers, there's a judgment of 6.2 million rand that remains unpaid. There's no intention on the part of Mr. Zuma to pay anything. So, let me start first by saying, your Lordship is not sitting on appeal or on review. You are asked to reinterpret an order of the full court of this division to which you are bound. Moreover, it is endorsed by the Supreme Court of Appeal. You are bound to that judgment. Who else were 8 judges talking about when they said the money must be repaid? Now, to answer my learned friend for the first respondent's plight, that Mr. Zuma is actually a victim, and you must not incorrectly convey the sympathy of the applicants towards him. That was my submission, because I cannot divorce myself from my mind what I see, observe, read, and experience every day. It is somewhat puzzling that everyone formed the view at various stages that he was entitled to funding, and then relied on 2 sections of the State Attorneys Act that say nothing of the kind, because everyone knew that the funding was for the criminal prosecution against him personally. Now, in a joint practice note filed by Mr. Zuma's junior counsel, because they didn't participate in that process when Judge Ledwaba wanted us to file a joint practice note. In that practice note, they say that it's common cause that at all relevant times Mr. Zuma was acting in his official capacity as either Vice President or President. Now, that's simply not true. The criminal prosecutions are against him personally, and never in his official capacity, and certainly not whilst acting in the course and scope of his duty. To whom was he acting in the course and scope of his duty? Certainly not to the country. So, those judgments are binding on your Lordship. The orders are clear, and I think my learned friends for the first respondent are creating smoke and mirrors around words such as may. That is usually language written by, used and written by appellate courts, I would submit. But to expect the may to have been shall, and for us to debate it in these proceedings, is simply untenable. But what is the main point? That is not Mr. Zuma's case in his answering affidavit. He doesn't say in his answering affidavit to this court that the orders are unclear, and I will be asking the court by way of a counter application under a notice of motion that your lordship must reinterpret. This is straight from the bar, and at 99 he catches us off guard and he says, well, what are we going to do with this person? We chuck him out on the street, and it's the state through various individuals who caused this. Now, if we were to believe for 1 minute that Mr. Zuma is and was as innocent as he is portrayed to be here and was not aware of anything, then what are we to believe? That all the senior counsel, specifically Mr. Kemp, who was a very competent senior counsel, never said to him that you're not being prosecuted in your personal capacity but in your official capacity, and on the basis of that we're going to apply for state funding. Was he never part of such a discussion?
But that's not the subject matter.
It's not the subject matter, but in the context of your lordship being asked to reinterpret the orders, firstly and respectfully, your lordship does not have that power. There's no application before you to reinterpret the orders. It would be exceeding the powers, and again, respectively, you are bound to the two judgments.
Yes, but Mr. Vakumides, if you go to paragraph 88
Of
the full court judgment, paragraph 88, D2, the wording of the order, particularly paragraph D2, it says, take all necessary steps, including the institution of civil proceedings, to recover the amounts paid by the state for Mr. Zuma's legal costs referred to in D1. Now, Mr. Masuku highlighted this. He said, well, the orders sought by both the DA and the EFF in very specific terms before the full court were that Mr. Zuma himself make payment of those amounts. And yet the full court, aware of that is the order that's sought, frames its order in a much wider way. It's not limited to Mr. Zuma. It just says take steps to recover. So this was the argument, one of the arguments of that Mr. Masuku made, which was, well, it doesn't specifically say only Mr. Zuma. It's not limited only to Mr. Zuma. His main argument was, well, in fact, it shouldn't involve Mr. Zuma at all, because he's not the one who made the decision to make the payments, whatever representations were made on his behalf. But that even if he is in the queue to make payment, the first port of call ought to be those whose conduct was in fact constitutionally delinquent, and that is the officials of the state attorney, and that in terms of the PFMA, you must follow that remedy as a remedy of first instance. So that's what I understood the argument to be, that to seek an order for the payment of the money of the full 28 million now directly against Mr. Zuma is putting the cart before the horse, because there was no order that said Mr. Zuma must pay. I understand your argument and Mr. Rosenberg's argument that it's contextual and that one must look at the totality of the judgment and not specifically at only certain paragraphs. So, and obviously that is the Constitutional Court, the Appellate Division have said that's the the way in which it must be done. It's a unitary exercise,
Yes.
context and so on.
But who participated in the proceedings? It was Mr. Zuma.
That's your contention, but just bringing you back to Mr. Masuku's client and his argument is focused on the express wording. He's drilled down to the explicit wording, leaving out context, leaving out the background.
Yes.
He says there's a finding of a breach of constitutional obligations. There's no finding that Mr. Zuma himself breached those obligations. It's others who did it, and now there's a remedy for that breach.
Yes.
And those who committed the breach, although Mr. Zuma would have been a beneficiary of the breach, but those who committed the breach are the ones that in the first instance must be held to account, so that people don't breach the constitutional obligations.
Yes.
As a beneficiary, whether intended or unintended, but in this case intended, he's last in the queue, because had he known that it was unlawful, had they not breached their duty as they, in its terms, he would have embarked on what's colloquially called a pay-as-you-go basis, and he wouldn't find himself today with this, facing a claim for this hefty amount.
Yes.
So I understand, I think I understand your case, and I understand his case. I think that it's something I have to consider.
I find myself in a very difficult position to understand how that argument may be accepted as legally tenable, because it's amounts paid by the state for Mr. Zuma's legal costs. So now, if it's not Mr. Zuma, the beneficiary of those legal costs, then who? Is it the state president? Is it the director general in the presidency? The legal officials? Mr. Fowler, who also made a decision several times?
Well, the implication is that, yes, to go by way of an analogy, the argument is, well, someone inherits as a result of the murder of somebody. And the state then says, well, we know who the murderer is, but we're not going to prosecute him and hold him to account for the murder. We know he did it. Let's rather just go and get the inheritance from the person, because he happened to know the wrongdoer.
Yes.
And that's really the argument, saying, well, you're skipping a step. They're saying you can't skip the step. That's the argument.
My Lord,
it's for me to decide whether that argument is going to carry the day or not.
But Justice Meyer speaks about the South African public, and he says this is they can be forgiven to have believed otherwise, but this is the correct position. Everyone knows that this is the liability of Mr. Zuma. Now, I say again, without intending to repeat myself, there is no application before you by way of a counter application and a notice of motion based on some cause of action asking your Lordship to reinterpret. You must now look at these paragraphs and say, well, I don't actually see, ignore everything else, but just focus on D Roman 2 and say, well, there might be a whole lot of people, including former President Thabo Mbeki and the current president, who also signed off on it. The current president said the funding will continue and will only cease when a court sets it aside, and that is what happened. So we're making much of a muchness here, and I don't think that is the case before you, with respect. But even if that is something that Mr. Zuma can be suited with down the line, if he can identify a legal right in terms of South African law, then it must follow that he has a remedy, not so. Now that he knows all the elements, he can then in turn hold whoever he wants liable. It's a far stretch for him, but that is what he can do. But there's nothing before you, a counter application to say, I'm not liable, it's actually X, Y, Z. And we, on behalf of the applicants, told your lordship the entire story. We've annexed every single document. You know who the author of the document is, you know the reasoning for the funding. There was one state attorney who's deceased, so all the blame does not fall on Mr. Chowe. There was a whole series of events. So who must we look at now, if not Mr. Zuma? In his affidavit, when he says he received the initial demand for the 18 million and something, in his affidavit he said, I didn't have sufficient opportunity to study the document. Now your lordship debated that with Mr. Masuku. The first accounting, before the appeal. So the state attorney didn't take any steps, further steps after the demand, because Mr. Zuma had been successful in the petition and it still had to run its course in Bloemfontein. So the inactivity of, the so-called inactivity of the state attorney during that period must be rejected. There was a pending appeal, and in terms of Section 18, all the orders are suspended. So, just 1 second, my lord. My learned junior has alerted my attention to. Yes. So, paragraph 52 of the High Court judgment. Can your lordship please go to that page? It's 001-81. So, what Justice Mayer says there, the papers before us do not reveal any real prejudice to Mr. Zuma. On the contrary, on 26 September 2008, Mr. Zuma in writing undertook to repay the state attorney in full on demand, and he does not claim to have been unable to make the necessary arrangements for this eventuality or to be financially unable to pay back the full amount within a reasonable period of time. Now, why would Justice Mayer have said that? And if Mr. Zuma wants to rely on the actions of others, why did he personally sign the undertakings to repay? So both the High Court and the Supreme Court of Appeal quite aptly distinguished between relying on that undertaking, in my view correctly so, because the undertaking was not good enough to succeed easily to succeed in a claim thereafter, and that's why the relief is phrased. They say it would not be enough for us simply to set aside the three decisions on the basis of whatever legal basis they set aside the decisions without addressing the question of payment. Now, if Justice Mayer refers to in paragraph 52 and he says, well, he signed and undertook to repay. Now, in his mind, and if I have regard to his answering affidavit, one of the grounds that he relies upon is he hasn't been convicted yet. Now, who makes that who makes that submission. I haven't been convicted yet. I now know that I incorrectly obtained legal funding. However, I have not been convicted yet, and therefore I do not have to pay back the money. No one else was the beneficiary. And when we talk of beneficiary, I don't for 1 minute think Mr. Zuma shared in any of these legal costs. The attorneys and counsel were paid in accordance with their arrangement inter partes, but on whose behalf did they act?
Well, he was the recipient of the service, the benefit of the services.
That is who they performed services for. My Lord, I don't think I should make any further submissions. I've heard my learned friend for the first respondent. I maintain that this point of reassessing, reinterpreting the order at this late stage without a case having been made and from the bar is opportunistic, and it's simply trying to elicit empathy and sympathy from the court to say, well, other people acted together in concert or individually and led him to believe that he was entitled to it. Well, if that is so, objectively, then he can take steps as advised. Thank you.
Thank you, Mr. Sorry, Mr. Vakumides, before you, sorry, Mr. The 34 cents, mentioned it at the outset and it was forgotten by me. Perhaps you persist that you, with the amendment for the quantum by adding 34 cents.
Yes, I have to abide by a court order.
Yes, that's fine. Mr. Masuku, is there any issue over the 34 cents?
I mean, I'm sure 38 cents.
34 cents.
34 cents. I could pay for one.
Will you pay for it?
Yeah.
Thank you.
Okay. All right, so there's no issue. I grant the amendment on the notice of motion and without saying anything further about it.
Yes, thank you.
Yes.
My Lord, what we do undertake to do is we have to file an amended notice of motion reflecting the correct amount.
Yes.
And I don't think there's anything else that we should upload.
Yes, nothing. I asked my registrar to let you know, but perhaps now's an opportune time. At the conclusion of the proceedings, if each of the parties can send in word format to my registrar the form of the order that they say should be made. So the invitation's extended to yourself, to Mr. Masuku, and
Thanks,
Mr. Rosenberg.
Thank you, my Lord.
To do so, please. Thank you. Mr. Rosenberg.
Thank you, my Lord. I'm going to be brief, but it's appropriate at the outset, perhaps, just to circle back to what has become one of the central submissions on behalf of the first respondent. Can we just go back to the High Court order, not the order, the High Court judgment, paragraph 77 at 00193. And there the High Court was considering the appropriate remedy, because at 77, sorry, at the preceding paragraph 76 is headed appropriate remedy, and the court said, I now turn to consider the appropriate remedy, one that is just and equitable in particular circumstances. In this case, paragraph 77, the DA and the EFF argued that a just and equitable remedy required a repayment order. Mr. Zuma, on the other hand, argued that even if this court were to hold the agreement to pay his legal fees invalid, that would not automatically give rise to the obligation for him to repay. This is how everybody, including the court, with respect, understood what was an issue. So Mr. Zuma contended that this would not automatically give rise to an obligation for him to repay. The nullification of the agreement would not give rise to a payment obligation. That claim should be enforced by the state appropriate. So that was the understanding in paragraph 77.
You say that's the genesis of paragraph D2 of the order?
That is. Well, one traces it, in fact, further back to the original orders that were sought by the applicants in those cases for repayment by Mr. Zuma. The DA sought repayment by Mr. Zuma. So that's paragraph 71. And then I'm not going to overemphasize the need to read these paragraphs together and contextually. Your Lordship has already pointed that out. In paragraph 81, the court concludes that a just and equitable remedy in the circumstances of the case is one that requires the state attorney to render an account of the private legal costs that were incurred by Mr. Zuma and to take necessary steps to recover the amounts paid by the state for his private legal costs. Again, with all due respect, there can be no other party by whom repayment is to be made in those circumstances than Mr. Zuma. And the paragraph concludes that as follows: simply declaring the agreements and the decisions to appoint private legal representatives and to pay Mr. Zuma's private legal costs unlawful without ordering repayment would not achieve the remedial objects inherent in the relief which a court should grant in the vindication of the rule of law. And paragraph 82, the concluding portion of paragraph 82, Mr. Zuma, although uniquely positioned to present factual material to contradict the EFF's proposed remedy, failed to do so, nor did he explain why he should be entitled to retain the benefit of the lawful payments made by the state for his private legal costs. In his answering papers, Mr. Zuma offered no factual material about his personal circumstances or any other circumstances to counter the contention about his ability to repay. One can observe in passing it would be incongruous, if not entirely inappropriate, for a court to conclude that a repayment order is the only just and equitable remedy without having applied its mind against whom that order would apply. It's inconceivable that a court could have properly exercised our Section 172 discretion almost in vacuo. And that's really dispositive of the argument. But perhaps to put it beyond any possible debate, if one turns to the SCA judgment 001-113, paragraph 19, the issue that is raised on behalf of Mr. Zuma on appeal was the just and equitable order requiring him to pay back the money was contested. That was the ground of appeal which he advanced. And the SCA dealt with that in paragraphs 44, 45, and 46. And in 44, the SCA points out in the last 5 lines as follows, in his last 6 lines. In his answering papers, Mr. Zuma offered no factual material to counter these contentions. Accordingly, there was nothing before the High Court to suggest that the order sought was not just and equitable in the circumstances. Arguably, consequent upon a finding that payment should never be made, it may have been the only just and equitable remedy. And in the context of that paragraph, it's quite clearly just and equitable that Mr. Zuma should repay. I don't think that there could be any sensible contestation about that. Paragraph 45 continues in a similar vein. A just and equitable remedy in this case, so the court found, requires a full and complete accounting by the state attorney under oath and an order directing Mr. Zuma to repay to the state the legal costs incurred on his behalf. So the SCA has clearly interpreted, construed the order. So there's very little room for this court, even if it was so minded, to attempt a construction of the High Court order that runs entirely counter to the arguments that were put up to the SCA and to the SCA's construction of that order. So, with great respect, Your Lordship is required to follow the SCA's construction of the order below. And, of course, paragraph 46 puts 44 and 45 in context, because some emphasis was made of the wording in 44, for example, the final two lines, arguably consequent upon a finding that the payments should never have been made. It may perhaps be the only just and equitable remedy. And similarly framed remark in paragraph 45, where it says a repayment order may well be essential to remedy the abuse of public resources, vindicate the rule of law, etc. What the court is there saying is, in the context of a challenge to the court below's discretion in determining what was a just and equitable remedy, the court was in fact saying not only that that was a proper exercise of the discretion, it went somewhat further in saying probably that was the only order. That it wasn't just that the court below was faced with reasonable alternatives in the exercise of its discretion, it properly exercised the discretion. The point the SCA was making in 44 and 45 was really there was probably only one order that could possibly have been made. And that's the prelude to what it says in 46, that it's not going to interfere with the exercise of that discretion.
You say the last sentence of paragraph 45 puts it beyond question.
Yes.
Because if the order, paragraph 88D2, was construed as involving anyone else or any other party, this sentence would be superfluous.
Yes.
It wouldn't make any sense.
No, the SCA has construed the order.
Yes.
Even aside from the SCA's construction with respect this court is bound, the court has my submissions that it is inconceivable that a court could properly exercise a just and equitable discretion to repay without applying its mind as to who is in fact bears the burden of that obligation. And for the rest then, your Lordship heard submissions that in fact it wasn't just and equitable for Mr. Zuma to repay, and various reasons were put up, and when your Lordship sought to test that by indicating, well, on what basis could it be revisited, given the findings of the court, the High Court, and the approach of the SCA, the submissions essentially amounted to the fact, to no more than this was unfair and there was no fault on behalf of Mr. Zuma, and that was supplemented by a suggestion that Mr. Zuma's arguments regarding clean hands, the doctrine of laches and the like, had not been fully treated by the High Court, and we were challenged to point out where the High Court had properly given attention to those arguments. We're not going to respond to that challenge. If the High Court didn't properly respond to the argument why it wasn't just and equitable for Mr. Zuma to repay, those are arguments, of course, that should have been produced to the SCA at that stage. It's certainly not the case that Mr. Zuma is not permitted to submit why it wasn't just and equitable, or isn't just and equitable, that he should repay. Of course he can make those submissions, but he can make those submissions up to a point. He can make those submissions in the High Court, he could make those submissions in the SCA, but there comes a point where it's no longer open to him to continue repeating those submissions. And we've passed that point. It's abundantly clear to everybody. The fourth respondent has prepared a draft order. In that draft order, amongst other things, it asks for costs, and as to the question of costs, the fourth respondent seeks a cost order against the first respondent. In the fourth respondent's notice of motion in the counter application, it initially sought a cost order only in the event of any party opposing the relief sought by it. The first respondent has filed a notice, albeit out of time, opposing the relief on certain legal grounds, going to standing, going to the question of interest, going to the question of the appropriateness of a supervisory remedy. The first respondent has perceptibly weakened on the question of the challenge to standing. I'm not quite sure whether they formally abandoned it, but they certainly lost any enthusiasm for that. As far as the question of interest is concerned, we stand by the submissions that we made in our earlier submissions, and that we expanded on somewhat in our supplementary submissions. I'm not going to repeat them here. I didn't, in fact, understand counsel for the first respondent to, in fact, challenge the applicability or challenge those submissions ultimately, as far as interest is concerned.
The first respondent's opposition was at the root level, the interpretation of the order.
Yes.
Not what would follow. Presumably there would be no objection if the third party was to be liable,
yes,
that they would pay interest.
Yes.
So what's good for the goose, good for the
Yes.
gander type situation.
Your Lordship has our submissions that the question of interest is properly to be determined, as Your Lordship indicated, by this court, which has been called upon, as we framed it, to operationalise the recovery. And that's why interest is only an issue to be determined once the debt has been liquidated and once it's become due and payable. For the rest, in the draft order, what we do propose on the question of the execution process, if I could perhaps hand up a copy of the draft order that we propose, and I'll talk to it very briefly. In paragraph 1...
Is there a copy for Mr. Masuku?
Yes, I did hope to hand him a copy of that. Can you hand that? I'll just deal with it. You can share.
I've given you my copy.
Okay. In paragraph 1, we've adjusted the amount of the indebtedness. In paragraph 2, in relation to the steps that the state attorney is required to take, as far as the question of attaching the ex-presidential remuneration payable in terms of the Remuneration Act, Your Lordship has our submissions that issue is a question which can appropriately be determined in due course, and it's not an issue that requires or should be determined by this court. Your Lordship has our submissions that in certain certain respects, in relation to that aspect of the attachment process, one is dealing with a feature which is essentially akin to an emoluments attachment order or garnishee order that would be regulated by the provisions of Section 65 of the Magistrates Court Act and the debt collection process that's provided for under that section. So we've provided in that regard as follows, and I refer to the last four lines of the proposed paragraph 2, where we say, in relation to the attachment to satisfy the judgment debt, that this should include the first respondent's pension benefit or portion thereof, if required and subject to an order of court authorizing that such attachment order be issued after satisfying itself that it's just and equitable that the order be issued and that the amount thereof is appropriate. So all of that effectively stands over for determination if and when appropriate. And in paragraph 3, we provide for the supervision order that was presaged in the notice of motion. We've made one minor adjustment in that in paragraph 4 that the fourth respondent may reply to the State Attorney's reports within 1 month. We initially provided for a 3-week period. And paragraph 5 is the costs order that we propose as appropriate. Yes, I do have one reference to a case. It may assist your Lordship just to have regard to it. University of Stellenbosch Legal Aid Clinic and others, the Minister of Justice and Correctional Services and others, 2016 6 SA 596 CC, and it deals with the constitutionality of certain of the provisions of Section 65 of J of the Magistrates Court Act, which deals with emolument attachment orders. And we borrowed from that case the formulation that we've inserted into paragraph 2 of the draft order. Those are submissions.
Thank you, Counsel, for your presentations and your heads of argument. Judgment is reserved. In due course, I'll hand down a written judgment. It will be uploaded onto Caseline. My registrar will send it to your respective attorneys on the day it's handed down. I'll try not to delay unnecessarily, but in my defense, preemptively, I have quite a busy term, so I'm sure you'll be sufficiently patient. Thank you. Court will adjourn.
Thank you, everyone.
Thank you.